Hello, welcome to this short session. Today we're going to be talking about the Civil Code lease eviction. We're going to talk about security deposits and the transfer deposit when a property is sold. That's what we're going to discuss in this short session today. Hello, my name is John Enzing. I'm a licensed real estate instructor both in Louisiana and Florida. My specialty is to do one-on-one tutoring for you, the student, to prep you for the exam. This is for non-credited hours, doesn't count towards your 90 hours here for Louisiana. And it's just a one-on-one to get you ready for the exam and clean up anything that you don't understand from common law, including math, civil code, and other state content. Now, if you want to book a session, all you have to do is go to privatetutoringsession.com, privatetutoringsession.com, and schedule an appointment, or you can email me at john.enzing@gmail.com. All right, let's go ahead and get into our session here. Again, we're going to talk about Civil Code lease eviction, security deposits, and how to transfer of the deposit. All right, first thing we're going to look at is eviction, okay? So every state has different revised statutes when it comes to their leasing laws within their state. Louisiana Civil Code is very, very adamant about the lessor following, which is the landlord, following these rules. Otherwise, they could be liable for fines and attorney fees, etc., that they would be responsible for paying the lessee, okay, if they go outside of what the Civil Code law says. So we're going to talk about eviction first. All right, this is the failure to pay rent. Okay, you got a tenant in the property and they don't want to pay rent. New month comes around and you don't collect rent. You can expel and can evict the tenant, but you have to do it according to the Civil Code law. Now, the lessor, that's the landlord. That's who we're going to reference in this session as the landlord. The lessee is the tenant, okay, the one who's renting. So the lessor has got to give the lessee, the tenant, a 5-day notice to vacate. Now, this is for test purposes, okay? So there is a stipulation in the law that says if you annotate it on the lease agreement to waive the 5-day vacancy notice to vacate, you can do that. But for test purposes, you want to know that it's 5 days notice to vacate. The landlord, the lessor, must let the lessee know to vacate, okay? 5-day notice. Now, if the lessee or the tenant doesn't vacate after 5 days, in other words, they're still in the property, the lessor or the landlord has to go to the civil court, usually the city court, and usually they're held once a week, and you go to the city judge, and you got to file for an eviction judgment, okay, with the city court. That's the next process. Again, you got to stay within the steps of the Civil Code. Now, within 3 days of the judgment notification, which you notified or filed the eviction judgment, or if the court finds in favor of the lessor, which is the landlord, and the lessee is not vacated, then the court will expel the tenant, okay, or get them out, okay? So you have to give a 5-day notice to vacate. That's required. And then if they don't get out, you have to go to the city court and get a judgment, an eviction judgment in court, right? And then there's another 3-day time period within those 3 days of filing the notification, or let's say the tenants do go to the city court and get heard on their case. And if the judge finds in favor of the lessor, that's the landlord, again, and they still don't vacate, then that's when the court can expel them using law enforcement, okay? Now you got to stay in tune and you got to stay within the confinements of the Civil Code on eviction. Otherwise, you're going to be liable as a landlord. You can be liable for fines and restitutions to the lessor. So for test purposes, 5 days to vacate, and then within 3 days of the judgment, or if the judge finds in favor of the lessor and they haven't vacated, then the court can expel the tenant. Okay. Now let's look at security deposits. This is another area that the landlord's responsible for and has to follow the protocol. Okay, so what is a security deposit? Well, the lessor is going to provide security, a security deposit to the landlord, right? For the maintenance of the property to maintain in good order. And so when the lessor collects the security deposit, they're holding that deposit, but it must be returned to the lessee at the termination of the lease. Okay. Really, the only time that the lessor can keep full 100% is if the lessee abandons the property and just leaves. Okay. Can't find him anywhere. Abandons the property, that's restitution to keep it 100%. Otherwise, it's got to be returned to the lessor at the termination of the lease. Now, there are provisions for repairs. If there's repairs to be made, there has to be an itemized list of repairs by the lessor to present to the lessee. Again, this is done within 30 days, and the lessor can retain the amount of money needed to make those repairs. Okay? So if it's a $1,000 security deposit and the lessor comes up with an itemized list of $750, that list has to be presented to the lessee along with $250, which is the balance, to go back to the lessee. Okay? Now, here's the important thing. Here's what you want to really know for the state exam. If the tenant or the tenant may recover actual damages or $200, whichever is higher, plus attorney fees, court costs, and all that, if the landlord fails to follow the security deposit laws. Okay, so you got to watch that as a landlord, and then for the test purposes, know that the tenant can recover actual damage of $200, whichever is less. Now, the last thing we're going to talk about is the transfer of deposit. So the transfer of deposit is when, let's say you own a property. You're an investor, you own the property, and you're getting ready to sell the house, and you got a tenant in the property. It's leased. They got a lease on it. So you're going to transfer a lease with the sale, and when you transfer the property, remember, prorated items like taxes, homeowners association fees, all those things will be prorated except the security deposit. That's not split between the buyer and seller. That's 100% transferred to the new buyer. Okay, so the buyer gets 100% security deposit of that lease that's in process during the transfer. Okay, and we're talking about a sale, a deed transfer. So 100% of the security deposit is going to be transferred to the new owner. Okay, so very important to understand. Eviction, 5-day notice. You got within 3 days to vacate, and then within 3 days of the judgment notification, or if the court finds in favor of the lessor and the lessee does not vacate, the court can expel. Okay, security deposit, you got 30 days to return the security deposit. If you're going to itemize the list because of damages, you have to give that list to the lessee, and then anything that's going to be difference, less the repairs, is going to be refunded to them in the deposit as well. Watch the landlord's responsible. If he doesn't follow in the security deposit, the tenant can recover $200 or actual damage, whichever's greater, plus costs and attorney fees. And then the transfer of deposit, that's where the property, when it's sold, 100% of the deposit is transferred to the new owner. Okay? Listen, I hope you enjoyed this short session on Civil Code lease eviction, security deposit, and transfer deposit. Again, if you need any help tutoring and you want to get some one-on-one training to prep you for the exam, go to privatetuturingsessions.com, privatetuturingsessions.com. Look, the real estate business is really fun. Enjoy your career. And again, if you need some help, I look forward to seeing you. Bye for now.